Welcome to Pro Se Lawsuit Center, where we provide affordable, battle-tested legal options that the ordinary people can use to control the court process and defend yourself, your rights, or your property without an attorney. I'm Coach Neighbors, and in this video, we're going to be showcasing the next workshop that we got coming up, Case Dismissed, Next Move Workshop. If your case was dismissed, this is your next move workshop. Oh, we worked that in real good. Did an arrogant judge dismiss your case and laugh in your face? No hearing, no finding of facts and conclusions of law, nothing. Just dismissed. Oh, did he say it was Rooker and Feldman? That misapplied doctrine that Coach Neighbors is always talking about? Did the judge answer for the other? Oh, if that happened to you, the why, not the what they did to you. Why were they able? Why? Most people are told the dismissal means that the case is over. It's done. It's closed. Go sit down, that you lost. They tell you the judge decided on the facts, and that's never true because you're an administrative court, not a judicial. And the whole thing started with fraudulent facts, so it's smelly the whole way. In reality, most dismissals are procedural, not decision on the merits. And when you do not understand, the courts rely on that confusion to shut down the case permanently. This workshop explains that dismissal really, what it really means, why the courts dismiss your case, and the way they do it, and how to make the correct next move without falling into the same trap. If your case was dismissed without a hearing, without a briefing, without a finding of facts and a conclusions of law, without having other parties even answer, respond, whatever, this training is for you. If the judge answered for the players and tried to block you from you know where I'm going with that, this remedy's for you. What you're going to learn, you'll learn what a dismissal actually is, the different types of dismissals, and critical difference between a ruling on a procedure and a ruling on facts, due process violations, and why they are not the same thing, and why the courts treat each one differently. Procedural due process is about how the courts act, pretty much, in a nutshell. In this section, you're going to learn the plain language on how the courts violate the procedures at the beginning of the cases. At the gate, you'll learn how procedural violations appear as suit dismissals, judge raising defenses for the defendant, judge answering for the defendant, dismissals without a hearing or briefing, or dismissals without a finding of facts and a conclusions of law, which is what's needed to have any kind of an appeal opportunity. Denial of leave to amend, orders issued without a finding of facts and conclude. We're going to go over that because that is the biggest way to shut down an administrative judge. They're not going to provide that. They can't clean up what they started in, You'll learn why these violations must be challenged immediately and how to properly preserve the substantive due process violations to prevent them from disappearing from the record. This is going to be one of the most important workshops because we're learning how to stop the judge, and we roll with fraudulent concealment, which is a federal doctrine that holds a statute of limitations. So you can come in anytime the judge violates you. It don't matter how long ago it was. The statute of limitations is told when you bring fraudulent concealment to the table, and we have it on the table. Now, the substantive due process is about what's done to you and why it was unlawful, regardless of what the judge does later and what they did, why it lacked lawful authority. We're going to focus on examples of that, like property taken without authority, foreclosure, any kind of invalid statute and culture, not valid laws, fraud, concealment, lack of jurisdiction. We're going to cover all of those things. You will learn why substantive violations existed before the court's involvement, and you're going to learn why they still matter after dismissal when properly preserved. This is some key stuff that we should have been doing a long time ago, but we're learning that we need to attack this process in 2 steps and on 2 separate documents instead of just one. Now, the courts benefit when the procedural and the substantive arguments are all mixed together. We about to put a stop to that. Bam! This lawsuit explains the logic of even if there was an error, you still lose, is used to avoid accountability. That's how they avoid accountability. No, we're not going to allow them to do that anymore because we're going to do it in dirty. You will see how mixing these issues kills your appeal opportunity. Oh, wait, you didn't have no appeal anyway because they're not going to provide a finding of facts and the conclusions of law. Okay, and this stuff is usually hid behind the appeal miss. Now, you're going to learn why procedural filings to answer for themselves, not allowing the court to answer for them. Oh, let's go. I'm excited about this. I'm excited. So now we're separating them. Separating them removes the court's escape route and prevents your strongest claim from being buried underneath their wrong standard of BS. We're going to learn how to preserve procedural violations, what must be objected to immediately, and why their preservation matters for the appeal and reassignment. That's what they're using the conventional. Okay, we ain't going to appeal. Okay, we're doing this, why this matters, because this is the evidence that you're going to be taken to federal court when you sue their ass over there in the big pokey, in the doke. Y'all know what I'm saying? As it should be in the big pokey. That's where you take all of this court crap, the entire docket sheet from state court over to federal court to use as your evidence to prove the why. Not what. Remember, prove why they're able to violate you. The reason they're able to violate you is because they violate your due process with the statutes and all that. And they could not, and did not answer on the state court level to anything that you filed that you got from us. Because they can't. They can't respond to anything that you get from winningcourtnow.com in state court because we use federal court case law and federal acts, and they cannot respond to them with statutes and codes that aren't valid laws. Bam! And now we learn how to add the state, the government, the state, or whatever, the judge who's getting paid by, add them right to the counterclaim and then file in their case. And there ain't a damn thing they can do about it. You not only added them to their own case, you fixed it so they can't represent other people from the same and the judge can't litigate a case they're a party to. Now, if you wanted to be like a real butthead, you can add the State Bar Association to it. Bam! And now nobody from the State Bar can even help them. But nobody can anyway. And even after it gets put in federal court, when you file in federal court and drag their ass over there, they still can't respond. They can't answer to nothing that you filed in federal court because they still don't have a federal attorney. They're totally jacked. Bam! Thanks to the real-time feedback. I ain't trying to take all of this. Thanks to the real-time feedback from a lot of people is helping us figure out how to get this done in a different damn way. I'm getting a little worked up, but I don't care. They can come and haul me off. I already learned that if they show up with that big old ram thingy, then they got a no-knock warrant. And I ain't doing nothing to make them show up with that bitch. Otherwise, they got to knock and wait for you to open the door. I only done that 6 times or something. We ain't open the door no more. They can knock all they want to. I'm going to just say, y'all need to wait out there till I need to go get some toilet paper. Maybe I'll have it delivered. Okay, so you'll learn why the substantive claim survives dismisses and how the statute of limitations protect them. And how to plead facts without triggering their procedural trap. Now, I'm going to be showcasing the 2 documents that we put together for this problem. I have them on sale right now for $40 for the pair of documents that you need to smack the judge in the face. And you can invest in the documents and bring them to the workshop with you after you review them. Just if you have any questions, and we'll go over the document and both of the documents in the workshop to make sure that everybody understands it. And that's part of the focus of the workshop, but you don't have to get the document. You can make your own document if you want. The workshop teaching you how to separate the two things and do all that is the fire that we're bringing to the table right now. And the missing piece that's been making it easy for them to hide behind that shit. We're about to put an end to that. So I'm going to review the two documents that we structured to stop this problem in the workshop. And I'm going to offer them to the attendees for $40. They're already, they'll be on the website, so you can invest in them and then figure all that out. And now I'm also going to set this up, and I'm going to start on that. Hopefully I'll get it all done. Our student hub page that we set up for foreclosure stuff, we're going to use that page to showcase all the information for the current workshop or the next workshop. And in the Client Hub page will be all of the things that you're going to need for the course. Any PDFs or anything that you're getting free will be in that page. And when I'm going to start and when we're, it'll be noted when we're going to have the thing or whatever. If any changes come up, that page is how we're going to communicate. And now if you somehow can't access the page, you don't have your link, call me the day before, okay? Because I'm pretty busy on the day of the live stream. And even my grandma might have to, she might have to get put on hold. Okay, this package that I'm talking about contains an objection to the sua sponte dismissal, and then there's some more stuff on in there. Then it has a counterclaim. Well, it's not just a counterclaim. It's a counterclaim, a declaratory and injunctive relief for damages and for fraudulent concealment based on the interference with, this one was structured for federal bankruptcy. So for interference with federal bankruptcy, supremacy clause, and the due process rights. Now, if you're not in bankruptcy, then you can change that and put whatever you want in there. That's how that's set up. This one was set up for a bankruptcy situation. If you're facing bankruptcy or in bankruptcy court, you get this and smash them because you ain't going to get nothing done in bankruptcy. Okay. This one-step procedural filing to stop the gatekeeper and preserve the judicial violations. Step 2 is the substantive filing to expose the unlawful acts and protect your rights. So basically, we've been doing step 2 and forgetting and not doing step 1. So step 1 has been kicking us in. Not anymore. It ain't kicking us nowhere no more. Now you'll learn why preserving disorder destroys cases. So you're going to learn why not preserving disorder destroys cases and how the two documents work together and contaminating each other in the conventional program. In this workshop, those common mistakes, we're going to show you how to avoid some common mistakes. Arguing facts when objecting to a dismissal, attacking judges inside merits of the filings. We're going to show you how to avoid these things. Okay, because I know y'all doing them because I was doing them too. Okay, Okay, we're doing different now. Come on, coach, just work with me here. Letting the courts reframe a claim as an appeal. We don't do that anyway. We just rather go right straight in and add them to their own stuff, adding plaintiffs to the counterclaim. I bet your attorney didn't tell you to add plaintiffs to their own stuff. And then we're going to make sure you avoid filing one mixed up document that hands the court the easy way out. Now, by the end of this workshop, you're going to have a clear understanding of the procedural versus the substantive violations. You're going to understand what both of those are and why they were, and you're going to know which document to file and when. You're going to leave with the confidence that you're not done because the judge said so. No, we don't listen to them. You're going to lead with a strategy to challenge any judge on a state or a federal level. Actually, you already know that because they're not going to provide the finding of facts and the conclusions of law. Bam. But now you're going to understand how to put two different documents. The ability to build the proper state court evidence to use in federal court, remember? Oh, that's the state level. You missing the boat. Jam them, hop on over to federal court, and then take a complete docket of all of this. All of the why they're able to violate you, ignoring your stuff and not having statutes and codes that are connected to valid laws. I just go on for a while. You want to talk about why, because when you start talking about the what, you need an attorney. The knowledge and tools to dismantle an improper dismissal. You're going to leave with some damn badass power, too. Because you can see right here, we don't play. If your case or pleading was dismissed and nothing about it made any sense, this workshop shows you why. Case dismissed don't mean it's over. It means it's time for the next move. It's over when you go sit down and you give up. It's over when the fear paralyzes you into not doing anything. It's over when you allow their fear to control your head. Nobody like that works with me, so you already know where they're headed. You already know what they're doing. Get what you need and punch them in the beginning. Yeah, there you go, Judge. I know you're going to ignore my stuff, whatever. I don't have a case number yet, but just put it in a file, and when the attorneys and your buddies over there get done playing around and get around to me, this will be the first thing that I'm filing. I'm just going to straight file my objection to your interference. Oh, did I say I love my job? You'll also receive at checkout, okay? Now, after checkout, you'll receive a thank you letter containing the information that you need to code for the hub. The student hub that's on our website, we were using that for the foreclosure training. And to the documents that we're going to look at or whatever, and you'll have access to the download that you're going to get for free. So you're going to need a code to get in that hub. And then the day before we have the training, I will post the code to have the training on YouTube, or however we've been doing it. I will post the information for that in the hub a day before the training. And if you don't get it or can't get it or for some reason, let me know the day before the training. Okay, I don't really take a whole bunch of calls on the day that I'm having the training because I'm really busy adding extra stuff, making it harder than it had to be. But that's all right, because that's how we roll. So you'll get a checkout letter, and it'll have some information that'll allow you to get into the hub. And then in the hub, you'll have all the stuff and what we're talking about. And that's going to be our way that we're going to communicate. And then each time I have a new workshop, I'll delete the information on. The main hub stuff will be there. Then we'll just have a little section over here. We'll put all of our stuff in or something. That way, everybody will have one place to go to get all of the documents that you get for investing in the program or whatever. And then if you have any comments or anything you want to say, you can actually leave it in the hub, and I'll check it later. And so that's going to be a real cool tool for us to use. Now, you can call me and send me a WhatsApp payment, or you can pay on the website. After you make your investment, you need to call me immediately, so that I could put your name in the list, and I can register you for your seat in the order that you paid. If you text me, I'm not going to even pay attention, because I'm not going to take any seats from text messages. You have to call me and talk to me, and then I will let you know your seat's secure. I'll put your name down on the thing, and that's going to be the bottom line if there's a situation, because class is filling up for another class, and we'll do the class again. So if you miss it, but it's better to do the things the way coach is saying so that it rolls smooth. You'll also receive offer to pay letter at checkout. This stuff will be sent to the email connected to the payment method, and offer to pay letter is what we use in the premium foreclosure offense package to challenge the mortgage before you're in default. And that document is not for sale on the website. So I'm just saying, well, it is in the package, but it's not for sale as a standalone core document or any of that stuff, or a support document. Because of its speciality, it's in that package. So I'm going to offer that to the people that attend the workshop, and anybody that leaves me a video review at the end of the workshop within 30 or 40 minutes of the workshop, or even before the workshop is done, or a written review, I'm going to provide them with additional surprise. And I'm not going to say what it is, because I had 10 people or 12 people last, and Monica was the only one that left me a review. She took the minute and 38 seconds to leave me a review and her appreciation for the value that we brought to the table. So thank you, Monica. I appreciate that. Monica is attending this training for free of charge because I appreciated her taking the time to get my back. Now, let's go. Click the link down there, make your investment, and call me ASAP so that I can get you secured for your seat. And then we'll be ready to go. Pro Se Lawsuit Center. We bring the fire that they can't put out.